May it please the court. As someone who has earned a mayoral commendation in New Hampshire, and as someone who has changed First Amendment law in Nashua, I approach the court with all the earnestness in my command. Next, Facebook Vice President Lucky's observations about race are only part of the picture here because the emails between plaintiff and the state court will reveal that plaintiff only filed his dismissal with prejudice in order to run video in the court and to stipulate to damages being less than $75,000. All of this occurred prior to opposing counsel ever making any appearance. As such, this is much more akin to an amended complaint, and that was the entire point. Further, even if the 42 U.S. Code 1981 claims cannot be litigated now because of plaintiff's voluntary dismissal before, Mr. Lucky's comments all go to the breach of contract, fraud, and good faith and fair dealing, as we all know that the same set of operative facts can have several different, legal theories involved. Now, regardless of how the breach occurred, for example, a breach occurred. And, it's the same thing that this court noted in Darna. The same set of operative facts provide liability on several different claims. And Darna said that, and so does Reeves versus Carrollsburg Condominium Unit Owners Association, 196 Civil 02495. Sustaining plaintiff's summary judgment claims in a case in which a plaintiff asserted both 1981 and regular breach claims. Next, Vice President Lucky's observations are not hearsay at all. He was at all relevant times of his observation a direct report to the upper echelon, if not in the control group himself. He is the person in charge of diversity management, and his specific job function, Your Honor. There's more than enough to make his statement admissible for the purposes of a motion to dismiss, if not summary judgment. Wheel versus Citizens Telecom, 9th Circuit, April 29th, 2019. As the panel majority summarizes the law, the statement is not hearsay. It may be admitted against an opposing party if the statement was made by the party's agent or an employee on a matter within the scope of that relationship while it existed. Well, guess what? Mark Lucky noted on Tuesday, November 27th, 2018, that the following memo was written and circulated by me to all of Facebook's employees around the world. It was sent on November 8th, 2018, shortly before my final day at the company. Period. It's not hearsay. And for the opposing counsel to try to tell this court that it is reckless. The news of the day that I just heard, topping off last week's disclosure that IBM director of policy, the IBM director of policy, I forget his name, he's a Federalist. This guy says, look, Facebook needs to be, it cannot avail itself of absolute immunity anymore. And everybody knows that now, increasingly a number of legal scholars are saying it. It's all coming down in the wash. And at the end of the day, well, I'll get there in a second. May it please the court. Your Honor, last week I informed the court about the fact that the IBM Director of Policy concurs with me. He concurs with other attorneys like David Lukemeyer, who's the amicus counsel for Facebook. He concurs with a number of us that say that the law has been misapplied with respect to Facebook. That's right, Your Honor. 47 U.S. Code 230, the Decency and Communications Act, has been wildly misconstrued and allowed to overexpand into our culture these days. This is a law that was created back in the infancy of the internet 25 years ago, Your Honor, intended to protect fledgling internet companies, Your Honor. May the court take judicial notice of the fact that Mark Zuckerberg and Facebook are no longer a fledgling internet community, okay? Mark Zuckerberg is worth $85 billion. He does not need protection from anything. We need protection from Facebook, and everyone is saying that. Conservatives, liberals alike. And so the things I presented today are so important to us as a nation. And by the way, speaking of a nation, Facebook has now indicated that it is going to start minting its own currency and opening up banks, okay? Now, ostensibly, this is to promote maybe a greater involvement in banking by traditionally underrepresented communities. But again, judging by Facebook's history in this area, we can't trust them for that because their own director of diversity said that they practice discrimination in the campus and on the platform. Okay, so now they're going to do banking? Really? That's a scary thought. But, Your Honor, it's because nation-state authority is what Facebook set out for back originally when they founded it. Now, granted, their co-founder, Chris Hedges, has come out and said that he doesn't think that should be the case anymore, that Facebook should be broken up. Yes, he said that. But the original plan was for Facebook to go ahead on and become a nation state. And that's what they're doing. But they're doing it without any sort of guidance, without any sort of, what can I say, safety precautions. You know, there's no accountability. So, in the real nation state, which is the United States of America, we have a First Amendment to the Constitution, okay? And you cannot stop people from speaking unless they violate that, all right? So many of us are arguing that Facebook should be on a First Amendment standard regardless. So, you know, hate speech would fall out of the window unless you were actually threatening someone, okay? But, Your Honor, even if we don't go that far, even if we just say, wait a minute, legal scholars are calling for an objective viewpoint, an objective analysis of how the rule is being applied to censorship, okay? If we go by that, we can clearly see, Your Honor, that Facebook is not following its own dictates when it comes to hate speech. Hate speech says that I, as a black person, can self-referentially reference myself as a nigger. Just like that white woman did, I just showed you, Your Honor, who calls herself a cracker. There's no difference. Those are the two most approximately similar terms that blacks and whites could hurl at each other, are nigger and cracker, okay? And so we clearly see that they're not adhering to their own policies. Now, the question for you, Your Honor, when you go back to deliberate on this case, is whether or not you got to continue to get it wrong, as all these other courts have, or will you look towards some objective standard that's being urged here to recognize that this law has been outmoded for quite some time, and that you have the authority to help make a change without engaging in unwarranted judicial activism. That's all I ask of you today. Now, let's go back a minute to talk about what this case is not about. You may recall that the defendants brought up a number of cases over the years that I've tried. They brought up 3 that I lost, and we talked about 5 or 6 other ones, okay, that I won. So I think my win-to-loss ratio is pretty darn good, actually. But one of those cases they brought up was the one with Kelly Ayotte when she kicked me, the only black reporter, out of the room, okay, of a publicly advertised event. That one, I came to find out later, Your Honor, that my opposing counsel used to be Kelly Ayotte's boss, and was also the boss of the magistrate, Judge Langea B. McCafferty, who's now the Chief Justice in New Hampshire Federal Court, okay? None of them told me any of this, which is a clear-cut ethical violation, mind you, Your Honor, okay? So I'm not even going to count that as a loss, all right? And another loss I had that the defendants wanted to point out was King versus McLeod, where I was seeking individual legislators' emails relative to what they were doing and trying to name a road after a bad cop. Let's put it that way. Well, anyway, we won. The community, we won that battle, and no road was named after that bad cop. But the bottom line is that even though I lost that case seeking individual legislators' emails, come to find out years later, you can go in New Hampshire, and that case is hotly contested, with many legal scholars saying that it wasn't decided properly because I should have had a chance to review the particular emails to see if they were state business or not, okay? But that didn't happen. My voice wasn't heard. In this case, my voice will be heard. And years from now, Your Honor, I'm here to tell you, I'm here to tell my opposing counsel, the law is going to change. There's a movement afoot, and it's just a matter of time. Facebook cannot own all of us. And when that law finally changes, we're all going to sit back and say, that nigga told me so. And I'm allowed to say that everywhere except on Facebook. Pepper, let's go.